Good evening, everyone. I am CA Tarun Kumar. I would like to welcome you all on behalf of TechSmart. हमारे पास इस वेबिनार के लिए अराउंड 3000 रजिस्ट्रेशंस आ गए थे. सो मॉर्निंग में बिकॉज ऑफ सम टेक्निकल ग्लिचेस ये हो नहीं पाया. सो वी रिक्वेस्टेड डॉक्टर फोगला टू रिकॉर्ड अ वीडियो सो दैट हम उसको अपने पार्टिसिपेंट्स के साथ शेयर कर पाएं. टॉपिक फॉर द टुडेज वेबिनार इज टैक्सेशन ऑफ चैरिटेबल एंड रिलीजियस ट्रस्ट. So this webinar is organized by Taxman. So just to brief you about Taxman, Taxman is leading publisher on tax and corporate laws in India. It also maintains a database of acts, rules, case laws at taxman.com. And it also maintains a national website of income tax portal. Since there are no attendees in this webinar, so just to give you instructions, you can leave all your queries in the comment section. So here is the agenda for today's webinar. So as you all must know that new scheme of registration is starting from 1st June 2020. So the major point here is that concept of perpetual registration is withdrawn under the new scheme. So now organizations will need to revisit department after every 5 years. Although the process has been turned electronic. Further, if the organizations are registered under both the section 1023C and 12AA, then they need to obtain the registration only under one section. If your entity is already registered under section 12AA prior to 1st June 2020, then you need to make an application again within 3 months, that is by 31st August 2020. And the concept of provisional registration is introduced. So this concept is for the applicants where the activities are to be started by the applicants. Further, the applications which are pending with the department on the 1st June, they shall be treated under the new scheme. And the requirement of renewal of registration has come up that you need to renew your application after every 5 years. So now I'll introduce Dr. Manoj Fogla. He is an advocate by profession, FCA, and specializes in taxation, CSR, and other aspects of NGA. He is also leading author of various books. So now I would request Dr. Manoj Fogla to start with his deliberation.
Greetings, namaskar. Thank you, Tarun. Today it was unfortunate that we could not go ahead with the seminar in spite of such a huge participation, which was overwhelming. Anyway, we try to make the most of whatever we have lost. So now, as Tarun has explained, this Finance Act 2020 has embarked a new era of regulation and registration for charitable organizations. So before we go into the slides, I will just give a brief overview of the provisions, keeping in mind that all kinds of viewers and audience would be hearing to this telecast. Now, charitable institutions, particularly charitable and religious institutions, they are eligible for exemption from income tax, but subject to certain specific compliances, registrations, approval under the Income Tax Act. For instance, a charitable institution can avail tax exemptions in numerous ways. There is a section called 1023, where smaller institutions with less than 1 crore can get registration without approval. Government institutions, registration without approval. Then there are institutions, charitable, religious, educational, medical, they have to apply and get approval. Then you have the most popular 12A registration, 12AA registration. This registration is for general charitable institution, and it is the most popular form of registration. Apart from this registration, there is another registration, 80G registration. This registration is regarding donations. It gives benefit to the donor. So if you are registered, you are eligible to give benefit to the donor. Now, the Finance Act 2020 has changed the registration process of all these forms of registration. with the 1023C to 12A 80G. And basically all these registrations were perpetual and permanent in nature. Now they have been reduced, they are time bound, and a common limit of 5 years has been proposed by Finance Act 2020. But on the face of it, it looks to be a provision for rationalization of taxation. Few years back, we saw registration under Foreign Contribution Regulation Act also were changed to a similar pattern where the permanent registration was converted into a 5-year registration. A similar kind of amendment has been introduced in Finance Act 2020. But these amendments, the way the Finance Act has been drafted, I'm afraid it will lead to a lot of confusion, lot of probably litigations, and it will create a lot of hardship for both for the implementers and the subject matter of this law. Some of the issues at the outset I'm flagging off, then we will look at them as we go along. For instance, now as we have told that the highlights of this is that all registrations are now 5-year. Every 5 years you have to apply for renewal. And this process will start from 1st June. You have to apply for renewal. The first renewal will be an auto renewal. So without any verification, the department will allow the existing organizations, whether under 1023C or 12A, to continue with the exemptions, subject to various issues and compliances, which we will discuss. So you, without any hassle, are proposed to get an auto renewal after you apply from 1st June to 30th August, 3 months. Then there is a provision where an URN will be created, that is a unique registration number will be issued for all charitable organizations. This again seems to be a very good proposal, so that today nobody knows. There are estimates of 2 lakh, 5 lakh, 1 million 12 registered organizations. So, and even as we understand that these old registrations, the 12 registration number even is not available at the department level, because these are decentralized data and the data pertain to a period since the Income Tax Act started. So that it seems a very good thing. Then the other highlight of it is that an organization registered under 1023C and 12A cannot opt for both. Currently, an organization can have both 1023C registration as well as 12AA registration, and can opt for assessment under any one of these registrations. But this will be denied, and there are a lot of issues attached to it, which we'll also discuss. Then there is a provisional registration. Provisional registration, again, then all new organizations will be provisionally registered, and this without any verification. On the face of it, it looks a very good change, but once we look at it minutely, we realize that the provisional registration is subject to a permanent registration almost immediately the moment the activities are started. So those issues also we'll try to touch upon. Then all those organizations whose 12A registration is pending, who have applied for 12A registration and not received 12A registration, or applied for 1023C registration have not, all these organizations will be given a provisional registration, which will have a cascading effect, because under normal circumstances they would have got permanent registration, but if they are downgraded to a provisional registration, then it would be a kind of a letdown of the and a kind of a retrospective application of these provisions, where the organization have to apply again the moment the activity are commenced. Similarly, there are various provisions which have been fixed with the renewal processes. Renewal in any case is a new concept, because income tax law, we had a renewal mechanism for 80G and 1023C some years back, but now all are perpetual registration. So now this renewal process has come, This renewal process has also been subjected to cancellation provisions, which also are quite a matter of concern the way they have been drafted. So which we'll try to look into. Then when you go for a renewal, the new act, earlier we had the provisions that an organization is either registered or an organization registration is cancelled. In between, there was a provision of forfeiture. For a particular year, the benefits will not. But now onward, the organization will be subjected to various other categories, which will have their assessment implications. For instance, if an organization does not apply, then will it be treated as surrender? So surrender could be one category. Rejection or denial of renewal will be one category. Cancellation of renewal will be one category. Forfeiture of exemption will one category. And yet another concept which have been brought into Finance Act 2020 by virtue of a provision called Section 11(7), which says that one registration will become inoperative. So there yet another fifth category, when you have or you do not have the benefit of 12(8)(23)(c), still you, from an assessment point of view, you may or fall into a particular category which did not necessarily be under a cancelled category, and which will have serious tax implications. I must also remind you that though there has been no amendment to a section called Section 115 TD, this section is a section which gets invoked once the registration of an organization is cancelled. And this is a very draconian section where the income and exit tax is put, and the income could be taxed at market value. So now with these renewal processes, cancellation processes, the section 115 TD comes into business. इसका काम ज़्यादा चल नहीं रहा था, ये section अब business में आ जाएगा. So these are some of the major issues we'll try to touch upon as we go along. Just to have a look at the new scheme of registration, as Tarun has already explained, and this registration would be there. So I would not be running through all these slides. I will just touch upon the major issues in each slides, and accordingly we'll try to make most of these 30-35 minutes which are available with us. So the new scheme of registration, as I have already explained, that 1st June all have to apply for renewal, and this renewal between 1st June to 3 months from 1st June, and the kind of automatic approval will be given, and unique registration number pan India will be given by the income tax department to all the new as well as existing charitable institutions. The newer one will get a provisional registration. The existings will get the same registration, 12A and 1020C as the case may be. The new registration will be live and effective for 5 years. The registration will be renewed every 5 years. This concept of provisional registration we will discuss as we go. So now coming to one major change, a paradigm shift which has happened in this Finance Act 2020, it is that an organization can have only one registration, 1023C or 12AA. Earlier, organization used to possess both the registration, and they had the option to opt for even while filing the ITR, they could select under which section. Of course, the audit has to be done under a different form, so that option was available. But the new act says that both will not be available. Without going into the technicalities, in nutshell, let me explain that this, the way this section 11(7) has been drafted, it will come out with a lot of confusions. For instance, section 11(7), which is the section pertaining to denial of two simultaneous benefits, says that one of the registration, section 12A registration will become inoperative. Inoperative from the date of registration or from 1st June, whichever is later. So now on 1st June, 12AA registration of each and every organization technically has become inoperative if those organizations are also registered under 1023C. So एक 1023C registered organization अगर उसके पास 12A है, if you carefully read the act, on 1st June 12A registration becomes inoperative. The renewal processes, the sections renewal is about the live organizations which are operative. Inoperative organizations are required to apply under another section which is for provisional registration. So this is one controversy which comes out when we read section 11.7 that technically 12A registration becomes inoperative. In other words, it seems that organizations having 1023C and section 12A should continue with the 1023C registration, and they should apply for renewal under that account, and they will not have the option of having the other registration. Now, there are two more issues which we should discuss in this section. One is that if a 1023C registration, under 1023C, there are organizations which take benefit. For instance, government institutions. Government institutions, they are not required to take approval, but they get the same benefit under 1023C. Such institutions seems to have been excluded from the category. In other words, these institutions can have both 12A as well as 1023C registration if they have 12A. That is what the literal interpretation of the act is coming out. It may or may not be the intent of the statute. Now we come to another part of it. Since the act says that an organization can have either 1023C or 12A registration, now it is 12AB. So whether it can be opted and shifted. So now this issue also has been clarified in the memorandum to the finance bill. It says that only once an organization can switch. For instance, you have a 1023C registration and your 12A registration has become inoperative. In times to come, in future years, you may opt for 12A registration, and the day you get 12A registration, your 1023C will become inoperative, and vice versa, but only once, and the act does not envisage a continuous shifting of organization between these two provisions. There are some marginal differences between 1023C and 12A. 1023C is slightly superior, but we will not go into those provisions as a part of this particular session. So now another issue which comes to everybody's mind, that the moment an organization becomes inoperative or denied registration, whether 100 section 15 TD 115 TD will apply or not. Our understanding is that 115 TD gets invoked in case where there is a cancellation of registration. There is a fundamental difference between a surrender, a non-renewal, and cancellation. Even the cancellation provisions under the previous income tax, or rather existing income tax law prior to Finance Act 2020, we had section 12AA, in which there were two sections of cancellation, to 12AA3 and 12AA4. This section dealt with cancellation primarily for three reasons. One, the organization is not genuine. Two, there is violation under section 13(1). Three, there is violation under any other law. All these sections pertaining to cancellations have been reproduced in the new law. Apart from it, Under the renewal section also, there is a provision which talks about cancellation. So therefore, a cancellation presupposes an existence of a violation in three categories. The organization is not genuine, section 13(1) violation of any other law which has reached finality. If these three conditions are not there, there is nothing in the Income Tax Act to initiate or invoke a cancellation proceeding. Therefore, to our understanding, a non-renewal per se is not cancellation. Of surrender per se is not cancellation. This part is also we take authority for this argument also from the fact that the Act says that if you are notified under section 1046 or having approval under 1023C, then your 12AA will become inoperative. It doesn't say that your 12A will stand cancelled. In other words, even without 12A, an organization can continue to be a charitable organization. And to my understanding, there is nothing in the Act which stops a tax-paying charitable organization. Tax exemptions is a benefit which an organization may or may not claim. So based on this, we believe that 115 TD should come only if there is a proceeding of cancellation as envisaged in section 12AA 3 and 4 of the old Act and section 12 AB 4 and 5 of the new Act. So, so then we go to re-registration of trust. So re-registration, we have prepared a small slide. We will not spend too much of time on this, but the basic thing is that 1st June, everybody has to apply. There is a three months window. There is no window for delayed filing of application. So now, if you don't apply within 3 months from 1st June, then your application, your registration will become inoperative. So the moment it becomes inoperative, it goes down to the route of provisional registration. So you have to go through that route over and again, and it will have issues during the tax exemptions for the current year, because the tax exemptions will be available basically in a provisional case, which we will discuss later after 2 years. So we will see as we go along. So now, can CIT make inquiry at the time of re-registration? Existing organization, provisional registration, no inquiry. It is a kind of automatic registration. We have to wait for the forms and the kinds of information which would be required to be uploaded at the time. So bearing the content and the requirement of the forms, there are no other formalities which have been foreseen as far as provisional and re-registration is concerned. After 5 years, all these provisions will apply. So the provisions will apply when you are an existing provisional registration applies for a permanent registration, and after 5 years, when you apply for renewal, then only all these provisions will get invoked, and there are some other possibilities which we will discuss. Now coming to provisional registration. Now, provisional registration, the law we have already discussed, so I am just skipping through this slide. The provisional registration, now the problem with provisional registration is that the law says that you have to make an application 1 month before the commencement of the previous year, in which you need the tax benefits. So now a provisional registration, then the other issue is that a provisional registration actually is a misnomer, because a provisional registration does not entitle a person to start activities. In other words, the provisional registration just to start the activities, the moment you start activities, you have to apply for going for the larger registration, that is the 5-year registration, because now we cannot say. So two problems which we have to understand: one, you have to apply 1 month prior to the commencement of the act, the previous year. Two, the moment you get provisional registration, you have not started your activities. So those organizations which have started their activity, basically, when they receive provisional registration, they have to apply for permanent registration. So there is, though provisional registration is valid for 3 years, but if an organization engages in validity, has meaning, because even for one assessment year, you will not get the tax benefit. Within 6 months of your activity, you have to get your registration changed to a 5-year registration. So basically, it doesn't serve any practical purpose. Now, in provisional registration, let me share another complication which has arisen, which maybe might have missed many notice, that the law says all the existing applications for 12AA will be treated as application under the new law. So all new application will become an application for a provisional registration. So now all those existing 12A registration where the application has been made prior to 28th February, that is 1 month prior to the previous year for which tax benefits are sought, those organizations will be eligible for tax benefits from the year in which they had applied. But for those organizations who have already made a 12AA application after March, even if they get this registration, they would not be eligible for tax exemption for assessment year 2021. So, and so these are the issues which probably have not been envisaged when this law was made. Maybe CBDT has to come with a circular, section 119, regarding proper treatment of the existing applications, particularly those applications where the verification, inspection, everything was complete. So now the other issue is that a provisional registration which is not converted into regular registration be treated as a cancellation. To our understanding, a provisional registration which the light of the day will not be treated as cancellation, but that organization will not be able to get any tax benefit either. Then another doubt which comes to mind, that since the act talks about activity, earlier the act normally did not use the word activity. We are used to the words like purpose and application of income. So that particularly says that commencement of activity is what will propel the requirement of regular registration. So activity, to our understanding, now we will be looking for greater clarity, but to our understanding, activity is the moment a charitable organization doing application for charitable purposes. So any amount or anything which is admissible under as application under section 11, the activity would be deemed to have commenced. So this issue will get clarity as we go along. Now, application pending 1st June, actually we have just discussed under the provisional registration. The key issue, as has been placed in this slide, are that is a retrospective denial of tax benefit. If an organization has filed sometime in 2020 or even earlier, and all formalities have been completed, in such circumstances, parity demands that should be given a 5-year registration, but as the law Now all those organizations will be given provisional registration, and mostly organizations file for application after commencement of activity. Therefore, all the pending application, the moment they get their URN, immediately they should apply for that 5-year registration. So all these pending applications, unless some changes happen, they have to go through the process twice, and as a matter of fact thrice, because they may have gone one to the process, then to the provisional process, then again they have to go for making the permanent. The effective date of exemption, as I told, 1 year, 1 month prior to the previous year. So the provisional registration clauses for the existing organizations are not conducive, and they will, even if they get registration, they will lose at least 1 year's exemption. So then we will quickly move renewal of registration. Now, renewal of registration, when we are talking about an ongoing activity in future whenever a registered organization. So from 1st June, there will be no issue of renewal of registration. The renewal of registration issue will become effective only after 5 years. So after 5 years, an organization will go for renewal. And I'm not discussing the timelines. In any case, most of the timelines says that whenever, because whenever the certificate is expiring, you have to apply at least 6 months prior to the date of expiry. So obviously, 4.5 years from now, you have to make a renewal application. There again, there are some confusion, because the certificate from 1st June, the renewal application made, and it will be given sometimes towards the end of this year. But the tax benefits will be available from 1st June. Since the tax benefits will be, the first tax benefits will be available from 1st April, because exemptions are year on year. So if the tax benefits are available from 1st April, so probably this 5-year limit will start from 1st April 2020, though the registration certificate will be accorded little later during the year. So accordingly, based on the certificate, from the date from which the certificate becomes effective, 4.5 years would be the time for applying for renewal. But now the issue is that at the end of 5 years, the commissioner has 3 sections under which cancellation could be revisited. So one is non-renewal cancellation. So these 3 processes have been put inside the Act, and as I said, the section 12AB, the renewal section is section 12AB, if I remember correctly, section 12AB 1B, under which the commissioner at the end of the 5 year will renew or deny renewal. There also the word deny renewal and the registration have been mentioned. Then again, there are 2 other sections, section 12AB4 and 12AB5, where there is provision regarding cancellation, which I have discussed at the earlier part of this session. Now they just try to understand the technical difference. Under section 12AB4 and 12AB5, the cancellation provisions are available to the PCIT and CIT throughout the tenure of registration. So whenever there is a violation regarding genuineness, section 13(1), or violation of any other law, the department, the principal CIT and the CIT can invoke these provisions and cancel, so they need not wait for 5 years. Renewal is a process which is the prerogative and a privilege to the SSC to go for renewal. So when a renewal application is made, and if there is no proceeding pending under section 12AB4, 5, then at the time of application, there is no show cause or cause of action regarding any of the violation which results in cancellation. That is genuineness, section 13(1), and violation under any other law. While I am seeing this, let me also tell you that ironically, section 13(1) has been given for cancellation, but section 13(8) is not a reason for cancellation. Section 13(8) is commercial activities. So the scheme of income tax is that if an organization is involved in commercial activities and its exemptions get forfeited, it is not a reason for cancellation. It is a reason for forfeiture of income. So in such circumstances, in my personal view, the provisions which link renewal with uh, cancellation are constitutionally suspect, and we may see a lot of litigations in time to come, because the renewal process presupposes that the organization is compliant. You are allowed to apply for renewal if there is no proceeding under 12 AV 4 and 5. In such circumstances, during renewal process, a cancellation process is not understood, or an independent cancellation inquiry with evidence in possession at the on the part of the authorities would be a pre-requirement for such cancellation. So we have to wait and see how it goes. But in any case, all these three sections, if a cancellation happens, then section 115 D will get invoked, and it is a quite a harsh section, and it will have implication not only in your on your current year's income, it an implication on your existing assets. So that section again we are not discussing here. So the timelines are there in the slide, which again I am not running through them. Then something of rejection or renewal or non-renewal, this partially I have discussed, but let us have a look at it. So at the time of renewal, the PCIT or CIT has to give reasonable opportunity. So it is not an organization can be rejected at the discretion of the authorities. So the authority is duty bound to provide an opportunity of being heard, so that probably would be a window for organizations to protect their interest if there is a possibility of cancellation and the invocation of exit tax under section 115 TD. And the rejection order CIT before expiry of 6 months from the end of the month in which the application is received. So now, why the 6 month from the end of the 6 month is important? We should quickly tell that the existing judicial precedent says that the timeline given to the income tax department have to be adhered, and if an order is not passed during those timelines, suppose a renewal is not made during those timelines, then under the previous provisions of the law, the Supreme Court and various high courts have ruled that it will be treated as a deemed registration. To our understanding, those cases will still apply in the existing provisions, and if a cancellation or a rejection order is not passed within 6 months, then those case laws pertaining to deemed registration could be relied upon. So non-renewal of registration so if the year in which an organization renewal is denied, that year that organization will not get benefit of 1023C or section 11. Now, another issue is that if the organization does not apply for renewal or does not apply for this one-time registration after June, does it become a cancelled organization and will exit tax under 115 TD apply? Whatever we could understand from the Income Tax Act, myself, Tarun, my friend Suresh Kejriwal, we have been discussing. We believe that cancellation is a coercive provision, and the Act has various elaborate process attached to it, and the cancellation would require a proactive, reasoned order with opportunity of being heard. Therefore, any kind of surrender or inoperative nature of organization should not in itself result in cancellation. There might be further proceedings under some other provisions of the Act, which we have to see. We don't want to preempt at this stage. Now, some other provisions, corpus donations. Corpus donation is again a contentious issue, taxation of grant, corpus donation. So now up to Supreme Court, we have decisions that corpus donation is not taxable even for organizations not registered under Section 12A. But this issue again is very contentious. We, with effect from 1st April 2017, there was an amendment in Section 224, subclause 18, Roman 18, that is the definition of income, where this clause was added to the Act, saying that all donations, including corpus, by any body, agency, or a government entity, would be treated as income. So now, whether corpus will be treated as income for the purposes of 224 or not, this again is a question of interpretation. But under the existing law, the law was not very clear regarding the treatment of corpus donation. If an organization registered under 1023C gives corpus donation, whether such corpus donation is a permissible application or not, because corpus donation to another 12A registered organization in any case was not treated as application. So now the Act has brought parity between all the provisions across regarding corpus donation. So that is the provision pertaining to corpus donations and regarding institutes managed under Section 11(1). Then we just yet another radical change which will have a huge impact on the charities is donation. ATG we all know, and in the past charitable institutions which used to have ATG registration, they used to issue receipts and ATG certificates to their donor. Based on those certificates, donor used to get tax benefits. So it was basically the taxpayer used to claim the tax benefit. Now onward, ATG provisions are quite like this 26AS and TDS provisions, where the donee organizations have to maintain the record and upload with the rules, and appropriate mechanisms will be installed in times to come, so that the donee organization will provide the detail. So in other words, suppose you have made a donation to a particular charitable institution, then at the time of filing of return, you will get the credit of the tax benefit the way you benefit. So it again is a very welcome step, and it will help us to know the ATG benefits and the mobilization of fund under ATG throughout the country, and it probably will also help in reduction of misuse of the provisions of ATG section. So, now under ATG, the consequence of non-compliance for filing of this statements, there are some provisions under Section 234G, 200 rupees per day, and under Section 271K, a penalty of not less than 110,000 rupees, which may extend to 1 lakh rupees, might be imposed. So, friends, these were some of the our understanding of the provisions of the amendments made pertaining to charitable and religious institutions. Today, because we could not interact you and we could not take questions, please do write your queries. We will try to respond. You may write to me personally. We will provide my email ID, and there will be a email ID available with the mail where you received it will be provided to you. Now, with great to you all, I hand it over back to Tarun.
Sir, thank you for such a wonderful deliberation. I think you have covered most of the issues in this presentation. Still, I would like to ask you a few questions. Like since under the new law, the NGOs have been given an option to select either of the registration, that is registration under 12AB and 1023C. And since there is fundamental difference between 12AB and 1023C, so what do you suggest that what should an organization opt for?
To my understanding, the organizations should opt for a 1023C registration, because those law applies. I will give you some instances. For instance, section provisions analogous to section 13(1) are not specifically there under 1023C, under the provision of 1023C. Provisions pertaining to the Form 9A and 10, Form 10 regarding this 5-year accumulation and one, those provisions are not specifically there. So there are some marginal advantages in a 1023C registration, and 1023C registration again gives more clarity to your work. Because under 1023C registration, for instance, an educational institution should maintain clarity regarding being a solely educational institution. That clarity gets vitiated and diluted when it goes for 12A registration, and that clarity is very important from a point of view of application of commercial activities and the application of GST law, etc. So there are some advantages, even though these advantages have been diluted over the years. So 1023C is not as important or advantageous as it used to be in the past, but still it should be preferred.
Thank you, sir. Sir, one more question. Since the different timelines have been prescribed, like 1 month, 3 month, and 6 month to pass an order by CIT, and under the 12A AA, there was various rulings where it has been held that there will be case of deemed registration. So whether such deemed registration will be automatic or any legal route to be adopted by an entity to get the deemed registration certificate?
My understanding, there is a timeline pertaining to auto renewal, and there is a timeline pertaining to those renewal which are subject to inquiry verification, where the Act provides various provisions regarding the genuineness, books, records, etc., which we will know when the rules come, would be the requirement. To my understanding, the existing judicial precedents will apply for the renewals which will happen after 5 years, where due diligence and the discretion of the authorities will be used. And this 1 month timeline and this auto renewal timelines are in any case procedural sections. So therefore, you need not get into this deemed registration. It is a procedural issue, and it has to be sorted out by the department without taking shelter of these case laws.
Sir, one more question. Since under the new law, it has been prescribed that at the time of renewal, CIT may reject and cancel the application. So what an legal route an entity should adopt if its registration is cancelled, not only rejected, but also cancelled? So what will be the legal remedies available with an entity?
In my personal opinion, a renewal cancellation proceeding cannot be read simultaneously. Okay. Therefore, the use of the word also will be a subject matter of interpretation. and that particular sentence under section 12AB subclause B, which talks about renewal and also cancellation, as I have discussed earlier in part of my deliberation. So now renewal is something that you are entitled to renewal only if you are compliant, and cancellation proceeding is something which gets initiated only if you are non-compliant. रिन्यूअल शुरू ही तब होगा जब आप कंप्लायंट होंगे, कैंसिलेशन शुरू तब होगा जब आप नॉन कंप्लायंट होंगे. The section current 12AA 3, 4 and the proposed 12AB 4 and 5 section, clearly those sections are similar. It seems to be abruptly the use of cancellation with a renewal process. Ideally, maybe the CBDT through rules should come that a non-renewal may also result in invocation of cancellation proceedings, and the CIT should go through an entire process where a cancellation related issues will be showcased, an opportunity will be given that why these issues should not be deemed as a violation of genuineness, section 13(1) and other law. So in that sense, this legal route, I don't think, let us wait for the rules and the forms. I just have a belief that the CBDT has to come with a circular. It could be a clarificatory circular, or it could be a circular using the extraordinary powers of the CBDT regarding the use of the word cancellation, section 12A(B)(1) subclause B, that cancellation with renewal. We have to wait for that.
Thank you, sir. There are very few experts in the country on this subject, and you are one of very renowned name. Thanks for enlightening us with your expert knowledge.
Thank you, Tarun.
Friends, in case you have any comment, queries, you may leave in the comment section, and you will receive the PPT and ebook on this subject on your registered email ID. Thank you so much.